Good day, and welcome to the hallowed halls of Washington Farm Bureau here in Olympia. As with every Focus Friday, we have another exciting topic to discuss. This one is the personal comfort doctrine in the state of Washington. My name is Gwen Perkins, and I'm a claims director at Washington Farm Bureau. In Washington state, the personal comfort doctrine is a principle of workers' compensation law that recognizes that employees are still covered by workers' compensation during brief, necessary breaks for personal comfort, much like going to get a drink of water or visiting the restroom. The Washington State Department of Labor and Industries, or L&I, considers injuries sustained during these activities as occurring within the course of employment. Personal comfort doctrine law and legal definition of personal comfort doctrine is a legal principle that states that the course of employment is not interrupted by certain acts relating to the employee's personal comfort, such as short breaks for eating, drinking, using the restroom, or even in this day and age, smoking. The presence of safe and adequate facilities for personal comfort, such as clean restrooms, safe drinking water stations, hygienic canteens, which are lunchrooms, comfort break areas, etc., is part of the employer's compliance with OSHA standards. The doctrine indirectly encourages employers to maintain these amenities properly. If an employee is injured due to unsafe conditions in these areas while tending to personal comfort, the employer may face liability. Brief personal comfort activities generally occur during paid working times or at least not considered as unauthorized absences. Employers cannot penalize employees for taking these short necessary breaks, nor may they monitor the length of time that these breaks are taking place, especially those breaks or those interruptions to work that occur in the restroom. Given that such acts are customarily recognized as essential and do not break the employment relationship. There are 4 key aspects of the personal comfort doctrine. The first, incidental to employment. The personal comfort activity must be something that helps the employee perform their job better. A second key aspect is during the working hours. The injury must happen during paid working hours or during an official break. Thirdly, momentary departure. The activity cannot be a major abandonment of work or substantial deviation from the employment. And finally, on-site or employer-directed. Generally, the activity must take place on the employer's premises or at a facility near the job site. For remote workers, the doctrine can apply if the activity is at employer-directed areas or employer direction complicitly. There are 3 RCWs in the state of Washington that address the personal comfort doctrine. The first one is RCW 51.08.13. The second, RCW 51.32.15. And thirdly, RCW 51.36.040. You can look those up online if you want to read them in complete depth. The personal comfort rule applies when a worker is injured during a personal comfort activity. The injury sustained during paid working hours or during a lunch break, coffee break, or restroom break while on the job site. The activity was implicitly or explicitly allowed by the employer. As with anything related to workers' compensation, if there is questions or concerns about differing interpretations, give Washington Farm Bureau a call and we'll discuss them. Let's talk a little bit about examples of activities that might be covered. Taking a break, getting a drink of water, getting a cup of coffee, using the restroom, And let me remind you again, the time limits on the restroom are not something that we as employers should be monitoring. Other reasonable activities. Location and timing must be within paid working hours or during a recognized break. So if a person normally works from 9 to 5 and they come in at 7 o'clock and they slip and fall in the restroom, that claim might not be covered because it wasn't during the timing that the worker would generally be in the course of employment. Again, I hesitate to repeat myself, but it's necessary for you to give us a ring or send us an email and discuss any oddities that might be connected to a claim filed under the Personal Comfort Doctrine. Examples of activities not covered. Recreational or athletic activities. That does open up some questions because it really depends on whether or not if you as the employer are insisting that the worker attend. So let's talk about, we're going to go outside and we're going to play football. You know, it's a nice crisp fall day where it's football season, so let's play football. You don't have to come. If you don't want to, you can just sit and watch. You can have your lunch, whatever. Claim might not be covered. However, if John the supervisor says, we all are playing football today from 12 to 1, be there, be square, you are required, then the claim filed for an injury during that activity would be covered under the Personal Comfort Doctrine. Personal shopping trips or errands for personal reasons while on break. So Joe decides he's going to get his wife a bouquet of flowers. He kind of messed up the other day. It's an apology kind of thing. He runs out on his lunch break, visits the local grocery store, picks up a bouquet of flowers, sustains an auto accident coming back to work. Well, I'm sorry, Joe, but it's not going to be a claim. It's a personal trip that you took to get yourself out of hot water with your wife. So no claim. We can protest that if filed. Actions that represent a significant departure from the course of employment. So deviation from employment is always up for question, but this is something we would want to look at before we say not covered or covered. As well as unusual or unreasonable activities, we would want to chat about that before determining whether or not it's a valid or not valid claim. Also included in the not covered issue would be non-work related activities. So let's say I'm on the telephone and I've deviated from my workplace because I'm scheduling a doctor's appointment and I've been on hold for 15 minutes. Probably wouldn't be covered if I fell out of my chair and filed an L&I claim. So we want to look at significant deviation from work. We want to look at any of those things that might be a little odd that could either swing a claim as valid or not valid. For those of us who have workers that work remotely, that can be more of a sticky wicket. The Personal Comfort Doctrine can be more complex for remote workers. A lot of it will depend on whether or not the employer requires a worker to work from home. If the employer requires you to work from home, entirely possible an injury coming from your home and in the course of employment would be allowed. However, if you are working from home and it's flexible and the employer doesn't require it, you have an office that you can work at in the office building. If you fell out of your chair, it might not be a valid claim. Or let's say you aren't getting any calls in and the dog needs to go out. You take the dog out for a walk and you trip over a hole in the sidewalk. That is deviation from the course of employment, so probably would not be an allowable claim. So at the risk of repeating myself, because I want to make sure that everybody understands there are 3 ways a Personal Comfort Doctrine can go. An employee trips and falls while working. They're going to the break room. They're just going to be there a couple of minutes. They need to get a glass of water. This is during a paid break. This would be a covered claim under the personal comfort doctrine. A claim that might be open for interpretation would be if a remote worker who's injured on a break while going downstairs to make a snack during working hours. Is their home considered a second job site? Very possibly. So this is something we would want to discuss with you on an individual claim basis. Not covered under the personal comfort doctrine would be an employee who leaves the work premises during a break, like Joe went to get his flowers, to run a significant personal errand not directed by the employer and is injured during that errand. That would not be covered under the personal comfort doctrine. Investigating personal comfort doctrine claims should be investigated much like any other claim. However, there are other issues that may need to be addressed. Where an employer maintains a wellness program, provides a workout room on the premises, and gives financial incentives for its employees to participate during a paid break or lunch, injuries occurring during those activities may be considered to arise from the course of employment. So those are issues we want to talk about with you if you have those kinds of facilities in your workplace. Is this something that you want to continue to, discuss with your people, work on perhaps alleviating or mitigating the possibility of injury while using workout facilities? Two common misunderstandings are some people believe that any personal activity during work hours is covered. However, under the rules and regulations, only specific comfort-related activities are included. And secondly, it is a misconception that all injuries during breaks are compensable. The injury must arise from an activity deemed incidental to employment. What should you do if you expect a personal comfort doctrine workers' compensation claim will be filed? Much like you do with any other workers' compensation claim, injury, illness, anything that you think may be filed under L&I. First of all, follow Washington Farm Bureau best practices. Ensure that the worker seeks medical attention as quickly as possible. Obtain witness statements, supervisor's report, photos, etc., anything that you feel will support either the allowance of the claim or a protest of the claim, which would result in rejection. Then finally ask yourself, was the worker in the course of employment, albeit on a comfort break? If you have questions, give us a ring here at Farm Bureau. And for the sake of time, I'm not going to cover the 3 interesting cases that I've included in this presentation. But if you want to read about personal comfort doctrine, cases that have occurred in the state of Washington that are kind of interesting, there are 3 listed on these sites. Easy to find. Go on Google and Google the different information that's at the top. So I want to thank everyone for participating with us today and enjoying the information about the personal comfort doctrine. It's definitely an interesting subject with a lot of questions and a lot of different scenarios. Give us a call here at Farm Bureau with any claims or safety questions. Thank you.